Hi, this is Kim Jacobson, and I'm here with my colleague Robin Fox again. In this section, we're going to talk about what to do if you are the victim of sexual harassment, what an employer might be liable for, and best practices in preventing and remedying sexual harassment.
So, what should you do if you're being sexually harassed at work? Well, the first thing, if you feel comfortable, is to ask the harasser to stop. There actually have been studies that show that this actually works, at least a large percentage of the time. Just saying, please stop, you're making me feel uncomfortable, can sometimes work to end the harassment.
Robin, does an employee have an obligation to ask a harasser to stop?
No, Kim, they don't actually have to do that. It's only if you feel comfortable. But people should know that it does work, but they don't have to do this. In fact, if they don't feel comfortable, they should look at their company policies and who to report it to in the company. Now, as we'll talk about a little bit later, anyone they tell in the company management structure will be responsible for helping them get this conduct reported to the right person. But another place to look is in the company policy manual, which will tell you or should tell you who to report incidents of sexual harassment to. Also, if the conduct rises to the level of being criminal conduct, like an assault, you can also report to the police. Now, reporting to the police doesn't necessarily put the employer on notice, but any conduct that's bad enough to go to the police about, you should also report to the company. Usually, it's the supervisor, it's HR, or someone in the company EEO structure that would be the person to report to. But really, again, any management employee would have the responsibility for helping you get this information to the right person. Another conduct might be the union. And obviously, you can always file a complaint with CHRO or the EEOC. Now, at the current time, any incident that has happened to you prior to October 1 of 2019 can be reported to the CHRO and be the basis for a complaint as long as you contact CHRO within 180 days. For incidents that happen after October 1 of 2019, you actually will have 300 days to make that complaint to CHRO.
So your employer has some responsibility for harassment at work. And they should use care to prevent harassment from occurring. The one thing that we always talk about is having a sexual harassment policy in place. But I don't know how many times I've heard, and Robin, you've probably heard too, I think we have a policy, maybe we have a policy. I saw that policy a few years ago. I'm not sure what the policy says. So it's really great to have a policy, but if no one knows what the policy is, no one knows where to find the policy, or no one knows what the policy says, it's probably not really worth much more than the paper it's written on. So you need to also have training on preventing sexual harassment and training on what your policy is. You also want to make sure that you're aware of what's going on at the workplace. It's not a good idea to just kind of turn the other way and look away and just hope no one complains or nothing happens. You really want to monitor what your employees are doing. And this might even mean monitoring electronic devices such as cell phones or email accounts to make sure there's no inappropriate comments or conversations going on in those modes.
Exactly, Kim. Just what you're talking about, we sometimes hear from employees when we're working on their CHRO cases that management sometimes keeps a very hands-off posture, and maybe the managers stay in their office all the time and they don't walk around the shop floor or walk around the workplace and get a sense of what's going on. It's a really good way to keep your finger on the pulse of your organization if there is interaction between the management and the employees.
Another thing that's very important is if, in fact, you find that there is some evidence of harassment in the work, you want to take steps to end that harassment. And you want to do that pretty promptly. You don't want to have evidence that harassment's going on and then just wait, a month, 3 months, a year to try to do something about it, because it's not going to really address the situation and it will make people think that you're not taking it seriously. You also want to follow whatever disciplinary policy that you have in your office. Some offices or businesses have zero tolerance policies. Some have other types of disciplinary policies, but you want to use those as corrective opportunities. And the main thing you want to do is take every complaint seriously. Even if this is the fifth complaint that an employee has filed, and maybe the first four you found there was no evidence of harassment, the fifth one very well could have some evidence of harassment.
Actually, that's a good point, Kim, because I sometimes get the question, well, somebody's made 3 or 4 complaints of harassment and none of them have been substantiated. So can we go and discipline that employee for making all these false complaints? And my antenna goes up as soon as I hear a question like that. And the answer really needs to be no. You can't discipline an employee for making an unsubstantiated complaint because, as we've talked about earlier, harassment a lot of times will happen when there aren't any witnesses to see it. And so it really might be one person's word against another. And you want to encourage these complaints. There is a difference, however, between an unsubstantiated complaint and a false complaint. Like, for example, if you have an employee who accuses someone of engaging in sexual harassment toward them, and you find out that that employee was out of work for the entire week during the time of the harassment, so it seems like there might be a vendetta against that particular employee, you may be able to then discipline an employee for making a false complaint. But I would be very, very careful about any type of discipline against employees whose complaints just can't be substantiated.
Yeah, because we generally say a victim should not be adversely affected because they filed a complaint. So that's good advice, Robin.
Okay, so going to the prevention end, what are some best practices to prevent sexual harassment? Well, the first one obviously is don't sexually harass people. Now, sometimes for management, it's easier said than done to tell your employees to not sexually harass people. But if you let them know that that is clearly against the rules, give them examples of what types of conduct would constitute sexual harassment, it's certainly a good place to start. Another thing that has come up recently is maybe we should just avoid having men and women work together and there you won't have any sexual harassment. Well, that's not really an option. Women and men both have the right and the need to work in the workplace, and they need to work together. Not to mention the fact that men can harass men and women can harass women. So unless everybody works all by themselves, isolated in a little corner, it's not going to work. So one thing you can do is train your employees and demand and require that employees all treat each other respectfully. Now, that does not mean that you have to have a stilted, very formal and cold workplace where nobody says hello to each other and nobody engages in any little chit chat that kind of makes the workday go on better. But respectful treatment should not be all that difficult to require and enforce. The other thing you want to do is periodically renew and reinforce the training and your policies. Now, the new Connecticut law that we're doing this training under, the Public Acts 19-16 and 19-93, require that this training be repeated every 10 years. However, it may be even beneficial to do it more often, or at least to reissue your policies on a more regular basis so that employees know what the rules are with respect to sexual harassment.
Robin, you're giving a lot of good advice to the employers, and I'm wondering, is this advice all mandatory?
No, it's not mandatory, but it's something that comes up periodically and sometimes more frequently in our cases. So we're just passing along information that will hopefully be helpful at eliminating sexual harassment. After all, that is part of our mission. The other thing you want to do is use examples that your specific employees will be faced with. I mean, we've put out a couple of different vignettes that you've watched already and some more that you may watch throughout our training. And they may show a more office environment or different workplaces. However, we know that the people doing this training sometimes will be in retail environments, maybe in factory environments. So use examples when you're talking to your employees that they can relate to and situations that they may actually be faced with. Also, don't hold workplace events in inappropriate places. So, for example, we've gotten cases where discrimination was alleged when, for example, an employee was required to go and meet customers at a strip club because that's what the customer wanted to do. As you can imagine, that might create an uncomfortable work environment for many employees, whether they're male, female, or maybe they don't even identify as a binary gender. You want to have workplace trainings and workplace events in places where everyone will feel comfortable. And as you said earlier, Kim, monitor technology. You may not be able to monitor your employees' personal cell phones, but you can definitely monitor your workplace technology.
So what can an employer legally be liable for? Well, an employer is automatically liable for harassment of a supervisor that results in a negative employment action, such as termination, failure to promote, failure to hire, or lost wages. The employer can also be liable for a hostile environment created by a supervisor, unless it could prove that they had taken reasonable care to try to prevent the harassment and that the employee unreasonably failed to take advantage of that preventive or corrective opportunity provided.
So does this mean, Kim, that if a supervisor is telling dirty jokes and things in the workplace and an employee doesn't report them, that the employer is off the hook?
Not necessarily off the hook, but they can only do something about things that they know about. So if they're not made aware of it, it would be hard to remedy it. The employer can even be liable for non-supervisory employees if the employer knew or should have known about the conduct and failed to address it. So this is a lot of what we're talking about, that you can't really keep a blind eye. If you are a manager and you're walking through a factory setting and you hear off-color jokes left, right, but you're like, la, 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 I don't want to hear it. I'm going to put my fingers in my ears. That probably won't get you around being liable if someone ends up complaining about this kind of thing.
It's a good idea then that the managers probably should not wear their earbuds walking around the office.
Yeah, but I wouldn't tell them not to wear safety earplugs if they needed to.
True. So we often get the question on whether an employee can be held personally liable for harassment. Generally, the harassment complaints are made against the employer. However, individuals can be held liable for engaging in retaliatory conduct towards someone who makes a complaint, or for aiding and abetting an employer in discrimination. So, for example, if the supervisor harasses the employee to the point that they're almost making them quit their job or making the employer then take adverse action against the employee, the supervisor may be held liable for aiding and abetting in that discriminatory conduct.
Is that the same thing as cat's paw? I've heard of cat's paw.
It can be. Cat's paw is generally when the lower level employee or lower level supervisor is engaging in discriminatory conduct such that they make the employer take adverse action against the employee without knowing about the discrimination, the underlying discrimination. And the employer, for example, doesn't look into the conduct enough.
So it's really important how a company sets up their reporting procedure, because if people either don't know how to report, or it's some kind of convoluted reporting procedure, or the person the company picks isn't really adept in doing this kind of investigation, you're kind of setting yourself up for failure. So you should have a very clearly outlined reporting procedure that people can easily understand. It shouldn't be that you have to call this 1-800 number between 12 and 12:15 and talk to only this one certain person on the phone. Don't make it so complicated. Maybe even give them a variety of people they can complain to. Supervisor, HR, upper level management, something like that. And then you really want to be careful who you select to take these complaints of investigation of discrimination and harassment, and who's going to be the one to investigate. You want to have someone that has the ability to be neutral and to keep things discreet, but to also be thorough and make sure that they can identify the important witnesses to talk to and important documents or electronic media to look at.
That is a good point, Kim, especially having more than one person to help you access the system, because sometimes if one person is the one who receives all these complaints, what's an employee to do if that's the individual who's harassing them? Then you kind of feel like you have nowhere to go. So those multiple points of access are really important. So again, for an employer to investigate complaints, properly, again, like Kim said earlier, you want to select the investigator carefully, consider any potential conflicts of interest. Like you don't want the employee to be able to say, well, this complaint was investigated by the harasser's best friend.
So, Robin, what do employers do for small businesses where everyone kind of knows each other?
Well, knowing each other isn't necessarily a problem, but there are times where, especially where the harassment is serious, you may need to or want to go outside and have an outside neutral person do the investigation. There are numerous law firms that do these investigations and other private HR people who do it. Your company counsel can probably recommend someone also. You also want to maintain neutrality. Again, when you're dealing with a small company, people do know each other, but you don't ever want to have the investigator say, oh, Bob's a really good guy. He would never do the things that are alleged of him, because that's how harassment winds up happening and not getting remedied. You want to listen very hard to the employee's complaints. Ask them who witnesses might be, listen to those, follow up with those witnesses, document your witness interviews. And again, if you have specific policies within your company, you want to make sure you follow those policies. But it's very important to get the information from the complaining person and then follow up on that investigation.
And as we see in case law and also just in practical terms, the employer's investigation is really important. If you don't properly investigate, you're going to decrease employee morale, and there's a chance that you're going to either have to pay out a large settlement when you get sued or have some kind of either the CHRO or the EOC or a court finding against you in your favor, or not in your favor, I should say. This Vasquez case is a perfect example where an employer was held liable for terminating an employee who complained about harassment without actually investigating. The Vasquez case actually has an interesting set of facts. Miss Vasquez had endured unwelcome sexual advances in the workplace of a coworker, and it was pretty bold. He used to ask her out on dates, attempt to flirt with her, put his arm around her, touch her shoulders, made her feel very uncomfortable. She alleged that she had rejected the coworker's advances many times, and the harassment just kept getting worse. And he was sending her pictures of parts of his body and wanting her to respond. And when she ultimately did complain, she was actually blamed for having an inappropriate relationship with a coworker and was later terminated. And the employer in that case was found to be liable. So this is just an example of why you can't just kind of brush this under the rug.
Right. And in that case with Ms. Vasquez, the person who was harassing her actually said, well, she kind of initiated all the conduct, and they didn't even want to follow up and look at the text messages and the evidence that she had on her. So it seems like it was good that they were found liable. On the flip side, as they're frequently called, the Farragher and Ellerth decisions, those are two U.S. Supreme Court decisions, they show that if an employer has a policy against discrimination, trains employees on that policy, and enforces that policy, they can insulate themselves from liability for harassment, especially where the employee unreasonably failed to take advantage of the corrective action that the employer provided. Now, this will insulate an employer from liability for hostile work environment harassment by a coworker. It still won't insulate from liability for harassment by a supervisor that leads to a tangible employment action. However, wherever you can, limit liability, it's always helpful for employers.
So here we've listed some best practices where the harassment has actually been substantiated, where the company has done an investigation and said, yeah, there was some harassment here, something bad happened. Well, first of all, you want to follow whatever progressive disciplinary policy you have. So again, a policy is only as good as if you can find it, if you know what it's about, and if you can apply it. So you want to make sure that you know what the policy is, you know what it says, and that everyone in the office knows as well. And you want to apply this policy consistently. One of the biggest problems we find in cases that we have throughout all parts of discrimination on any class basis is that an employer will have a policy and will apply it to Jack, but not maybe apply it to Jane. And then the policy really is shown to be discriminatory. So you want to make sure everyone is following the policy and each employee is treated consistently and fairly under the policy. And you want to document whatever you do. So if you're substantiating that Jack had sexually harassed Jane, then you want to also document, was there a written warning? Was there a transfer? Was there a termination, or whatever you decide is appropriate under that policy? And you want to make sure the tone of your correspondence is professional and factual. You don't want to have some kind of report that has, foul language in it, unless that's part of the harassment allegation. You want it to be professionally written so that when this becomes evidence later, or could become evidence later in some kind of action or lawsuit, that you're not embarrassed by what it says. And even if you don't find that there was harassment, when an allegation of harassment comes up, that might be a clue to you that you might need to have some more training.
That's a good idea. Retraining is always a good idea for a number of reasons, Kim, because even if you can't substantiate that the harassment happened, it lets the employee who complained about harassment know that the company does take it seriously, because we're going to make sure that everybody knows that we have a policy and this is how to use it. So when the investigation is completed, again, like Kim said, you want to follow your disciplinary policies consistently. But the other thing you want to do is make sure that you circle back with the complaining employee. You want to do this for two reasons. Number one, you want to reassure them that they won't be retaliated against for actually filing the complaint. You want to ask them to please let you know if whatever remedy the employer took is working or not. So even if the harassment wasn't substantiated, you want to let them know that, look, we've retrained all these employees and please let us know if any new harassment occurs. The other reason is because frequently when we get CHRO complaints, the complaining party will say, well, I complained about harassment and then I never heard back from my employer. I don't think they did anything. And the employer will answer saying, yes, we did. We investigated. We spoke to the employee and nothing further actually happened. And besides, discipline is confidential, because under Connecticut law, personnel files and conduct are confidential. While we agree with employers that you don't want to go and tell people's coworkers, well, yes, we suspended John for 4 days because he engaged in harassing conduct, you do want to let the employee know that we did take action in response to your complaint. We hope that this action eliminates the discrimination, and please come back to us if it happens again. In this way, the employee knows that they're protected and knows that the employer has their back. And again, this is a change in the law that went specifically into effect with these new public acts, do not adversely impact the complaining party. So the complaining party should not have their work situation modified as a result of having complained about discrimination. And again, you want to make sure as an employer that you maintain records of this, of complaints, of the investigation, and of any discipline imposed. This will help guide you in the event of future complaints. You can look back and see what was done, so you treat your employees consistently. And it also helps all the parties to know how an employer responded to these complaints.
We're going to give some examples of what an employer might do if they actually find sexual harassment has taken place and they want to remedy it. Again, the first step is going to be to look at whatever your policies say, your disciplinary policies and your sexual harassment policies. But some options that might be out there, depending on the severity and pervasiveness of the harassment, you might relocate the harasser. You're certainly going to counsel the harasser. Again, training. Maybe the harasser needs more training. You might suspend the harasser, or if it's really severe and pervasive or repeated, a termination might be in order. But again, the main thing you do not want to do is relocate the victim, especially without their written consent, because the statute specifically talks about that. And we can't say it enough, always circle back to the person making the complaint so that they know that something was done, because in their mind, nothing was done until you tell them something was done.
Right, and make sure that they know that they can't be retaliated against for making the complaint, and they should let you know if the harassing conduct continues, or if maybe the harasser's friends and coworkers now start to gang up on that employee. Unfortunately, that does happen sometimes. Now, please pause the video and take quiz number 3 in the materials section.
The first question says, who should be interviewed during the course of an internal investigation of a sexual harassment complaint? The choices are A, the complainant, B, the alleged harasser, C, identified witnesses, and D, all of the above. Well, I think this answer is quite obvious. The answer is all of the above. Of course, you want to interview the person who's making the complaint and find out as many details about the complaint as possible. It's really the who, what, where, when, and why. Who was around, what occurred, when did it occur, if they know why or think they know why it occurred. You want to get all that information from the complaining party and really from anyone that you interview. You also want to interview the alleged harasser to find out their side of the story. Maybe they will just admit to what they were doing. Maybe they didn't even know what they were doing was wrong. Or they may deny it, and then you're going to have to make some credibility determinations. It's also a great idea to interview any identified witnesses. The complainant may identify people that were either in the area or overheard or saw what happened, and the alleged harasser may also identify similar witnesses. So the answer is really D, all of the above.
Okay, question 2. Should an employer immediately transfer an employee who files a sexual harassment complaint out of the harasser's unit to prevent more harm? The choices are A, yes, the employer needs to take steps to prevent ongoing harassment. B, no, the allegations might not be true and nothing should be done until after an investigation. Or C, maybe, the employer can propose a transfer for the protection of the employee, but the employee must consent. As we've discussed, the answer is C. The employer can propose a transfer to protect the employee, but the employee must consent. An employer cannot take adverse action or any action that might affect the terms and conditions of an employee's working environment after they've filed a harassment or other discrimination complaint, because this could be seen as punishing the person who was actually the victim of the harassment. However, you might want to separate the parties in case there is any ongoing harassment going on. In that case, you would want to possibly transfer the person alleged to have been doing the harassment. So the answer is properly C, maybe.
Robin, should the consent be in writing? The
Yes.
consent to transfer from the alleged victim?
Yes, it should be in writing, and that protects both the employee and the employer, because having a document in writing prevents people from later saying that I didn't really consent, or just the dispute as to whether or not they consented.
Question 3, true or false? An employer cannot be liable for a manager sexually harassing an employee if the sexual harassment is not reported. A, true. Employers are not liable for harassment they do not know about. B, false. Employers can be liable for the conduct of supervisory staff even if the harassment is not reported. Well, the answer is false. There's a distinction between managers and coworkers. An employer can be liable for sexual harassment by managers even if it didn't know about it, but it cannot be liable generally for harassment of coworkers unless it has been informed that the harassment is taking place. I just want to warn employers that you can't keep a blind eye. The answer isn't, I didn't know it was occurring, but it's happening all around you.
Right, Kim, that's what we were talking about earlier, where employers shouldn't closet themselves away in an office with the door closed and not pay attention to what's going on out on the shop floor or in the rest of the workplace. Okay, question 4. This is also true or false. An employer cannot fire an employee because they filed a complaint of sexual harassment that turned out to be unsubstantiated. A, true. Firing an employee for just filing a sexual harassment complaint in good faith is illegal retaliation. B, false. If the complaint turns out to be unsubstantiated, the employee has no protections and can be terminated. Well, clearly the answer to that is A. Firing an employee for filing a sexual harassment complaint in good faith is illegal retaliation. Now, we frequently do get the question on, well, what if we can't substantiate the claim? Then we just have an employee who might be a troublemaker and we should get rid of them. Well, that's the wrong attitude for an employer to take, because just because the harassment can't be substantiated does not mean it didn't happen. Harassers are often very good at finding places where there are no witnesses to what happened, so it cannot be proven. Now, that's just because it's not substantiated, that doesn't mean the claim was false. Now, if you have evidence that an employee falsely filed a complaint, for example, to get back at a former boyfriend or girlfriend or just someone that they don't like in the workplace, that can be dealt with as a disciplinary matter. But just because you can't substantiate the claim does not mean it didn't happen.